I'm Diane Weinroth. I'm Special Counsel at Children's Law Center, and I'm going to be talking about the substantive and procedural law of custody. There are three types of cases in which custody orders can be requested, can be entered. Divorce cases are cases in which custody can be part of the relief that is granted. In addition, it is possible for a parent or a third party to file what I call a standalone custody case. It's not related to a divorce. It's not necessarily related to any other kind of relief. The plaintiff is simply asking for custody. The procedure in divorce and custody cases is very similar, and we'll be talking about that more. There is a third kind of case in which the court can grant custody, and that is a civil protection order proceeding. The procedure in those cases is a little different, and we'll be talking about that separately. Essentially, protection order cases are domestic violence cases. They're cases in which someone is seeking a domestic violence restraining order because of violence in the home. It is possible for a court to award custody in a case like that. So those are the three kinds of cases in which you may be appointed as a guardian ad litem. I wanted to start by giving you an overview of where you will find the law related to custody. There are statutes that govern all three kinds of proceedings. Custody between parents is governed primarily by DC Code Title 16, Chapter 9, especially 16-914. That's where you'll find the most relevant material regarding custody cases between parents. In addition, there is a statute regarding custody cases filed by third parties, filed by individuals who are not parents. This statute is known as the Safe and Stable Homes for Children and Youth Act, and it's at DC Code Section 16-831.01. I want to mention that this statute wasn't enacted until 2007. So if you read cases involving third-party custody that date from before 2007, you're going to want to read those cases with care, because some of the law may still be relevant, but some of it may not be relevant anymore because it's been superseded by the statute. In addition, there is a statute that governs civil protection order proceedings, and that's at DC Code Section 16-1001. That statute essentially governs the protection order proceedings themselves, what makes you eligible for a protection order, the relief that the court can grant. It doesn't really address custody per se. The law of custody is really found in the other statutes that I just mentioned, which can be read together with the civil protection order statute to let you figure out how those proceedings work and how the court can decide custody in those proceedings. In addition, there are court rules that govern these proceedings. Divorce and custody cases are governed by domestic relations proceedings rules. That's what they're called. They're DC Superior Court rules. In addition, there's a set of rules called the General Family Rules that also govern divorce and custody cases. Civil protection order cases have their own rules. They're called the Domestic Violence Unit Rules. And the court rules essentially govern the procedure of these cases. The statutes address primarily the substantive law, the legal standard, presumptions, and other things that we'll talk about. The court rules govern procedure. We want to welcome you to DC Superior Court. This is where you will be litigating your cases. The DC court system is a two-tier court system. It is our state court system. DC is not really a state, but in most respects, legally, it functions like a state, and we have our own court system. It's a two-tier system in the sense that we have a trial court, and that's DC Superior Court. And there's also an appellate court, the DC Court of Appeals. We do not have an intermediate appellate court, so there's simply a trial court and one court of appeals. Almost all of the court offices and the courtrooms are in the building that's shown on the slide, which is at 500 Indiana Avenue. There are a few satellite buildings, but you'll be spending most of your time in 500 Indiana Avenue. I wanted to show you a little bit of an outline about how our court, how Superior Court, is structured in terms of how judges are assigned to hear particular cases and how the clerk's offices are set up. And this flow chart illustrates that. Superior Court is divided up into several subdivisions. Some of those subdivisions are called courts, some of them are called divisions, some of them are called units. You don't really have to worry about why the names are different, but these are essentially the subdivisions of the court. And each of those subdivisions typically is are divided into branches. And so you'll see as you start to get involved in these cases that knowing this will help you get oriented and will help you locate things. It will help you figure out where particular cases are heard, where the clerk's offices are, where you will find the files. It also highlights another point that I want to make, which is that in our court system, judges rotate. In some states, judges are assigned to one calendar, one docket, one division of the court forever, so that a judge is permanently a criminal judge or a civil judge or a family judge. But that's not true in the District of Columbia. In our trial court, judges rotate. Now, the rotations tend to be pretty lengthy, at least a year, often longer, but they do rotate. The case, however, in a sense, remains in the same place. So if for some reason a rotation takes place during the course of your involvement in a case, the case will stay on the same calendar, but you may get a new judge. With any luck, however, you will have the same judge throughout the duration of the case, but there's no absolute guarantee. Rotations tend to take place on January 1st, but again, a judge may be in the same assignment for a year or 2 years or more. The branches of the court or the units or divisions that you'll be operating in primarily are the following. The first one you'll see highlighted a bit on the flow chart is the domestic relations branch. That's where custody cases and divorce cases are assigned. So judges are periodically assigned to those branches, and your case will be in front of one of those judges. The other branch you will appear in is, it's not really a branch, it's the domestic violence unit. And there are calendars in that unit that hear civil protection order cases. So you'll learn more throughout this presentation and as you work on the cases about what that means and how the administrative functioning of the court works. But essentially, those are going to be the places where you're at, the domestic relations branch and the domestic violence unit. So now I want to talk about what custody actually is. We use the term all the time, but you need to know what it is you're litigating about, what the options are, what kind of relief the court can grant. I like to think of custody as a bundle of rights and responsibilities that flow between an adult and a child, typically a parent and a child, but conceivably between another adult and a child. So it's actually a bundle, but that bundle can be broken up into discrete individual rights and responsibilities. Typically, courts think of custody as having two large subdivisions: legal custody and physical custody. So that's typically what the court is deciding: who has legal custody and who has physical custody. There is a statutory definition for legal custody, and it's on the PowerPoint slide. Essentially, what it boils down to is decision-making. Legal custody is the right to make big decisions about the welfare of a child. The statute also provides a definition of physical custody. And physical custody essentially means where the child is and with whom. It means the child's living arrangement, who the child is with in space and time. There are 365 days a year, and that child is with someone, or someone is deciding where that child is all the time. So it means the child's living arrangements, who has access, what the visitation arrangements are, if the child is living primarily with one parent, but the other parent has access, has visitation. So again, and we'll talk about this more, those subdivisions can be broken up into even more discrete parts, but really that's how most judges and lawyers think about custody to begin with, as legal custody, decision-making, and physical custody, who the child is with at any given period of time. There's a quotation from a case that we like to provide you with that gives you a little bit of an idea about how this works in the real world, how legal and physical custody might interact, because obviously there are not always bright lines. Sometimes it's very clear what it means when you say someone has legal custody or someone has physical custody, but sometimes those distinctions blur a little bit. So the quotation kind of talks about how you try to operate in the real world when one parent has legal custody, but the other parent is the physical custodian at that moment. So we're going to talk more about how custody really works in the real world, but I wanted to use that as a starting point for another important issue, which is who has these rights? Who has custodial rights? If there is no court order, parents have joint legal and physical custody by operation of law automatically. And what that means is that the parents have coextensive, shared, equivalent rights. Each parent, both parents, have the right to make decisions about the child. Both parents have the right to have the child with them. And sometimes that works just fine. And sometimes it doesn't, which is when you usually get a court case in which a court needs a guardian ad litem. But in the first instance, from the moment of birth, both parents have equal rights. That's probably true as a matter of common law. It's probably an intrinsic right that parents have, but there is also a statute that states that very clearly in DC. It states that parents are the natural guardians of their children. I want to highlight that it doesn't matter whether or not the parents are married, and it doesn't matter whether or not the father's name is on the birth certificate. There's a lot of misunderstanding about that, but in the District of Columbia, a parent is a parent regardless of whether the parents are married and regardless of whether the father's name is on the birth certificate. In fact, illegitimacy has been eliminated as a status in the District of Columbia by statute. And that's probably constitutionally required. If you think back to your constitutional law classes, you may remember that there are cases that pretty much say that you can't discriminate or make distinctions between children who are born in wedlock and out of wedlock. So as a matter of law, it's really irrelevant whether the child was born in wedlock or out of wedlock. The kids have the same rights. And the flip side of that is that the parents essentially have the same rights, that you can't make a distinction except in very rare circumstances between a parent of a child born in wedlock and a parent of a child born out of wedlock. So as you can see by how I'm using the terms in wedlock and out of wedlock can be used, but they're really descriptive. They don't have any legal significance. And the parent of a child born out of wedlock typically has exactly the same rights as the parent of a child born in wedlock. So that's what I call the state of nature. That's how things are when there isn't a court order. But the court can allocate custodial rights between the parents. The court can clarify who has these decision-making rights and who the child is going to be with at any given point in time. The court can also award custodial rights to a non-parent, to a third party, under certain circumstances, and we're going to talk about those circumstances more later, but the court may have that power. Third parties in the District of Columbia don't have any inherent rights Family members don't have any inherent custodial or visitation rights. Third parties, other third parties, unrelated third parties don't have inherent rights, but they may be able to seek rights to custody or visitation from the court. So I want to take this one step further and kind of meld this discussion about who has rights, who can get rights, and what custody really is, to talk about what kind of custody arrangements a court can order. So you can start to think about what the court's power is, what parties might be willing to agree to, what the court can order, and ultimately what is in your little client's best interest, what is in the child's best interest. You need to know what the playing field is so that you can move forward accordingly. The DC custody statutes say that a custody order may include sole legal custody, sole physical custody, joint legal custody, joint physical custody, or any other arrangement that the court determines is in the best interest of the child. That's the statutory language, and the statute doesn't really shed much more definitional light on what all of that means, other than the basic definitions of legal and physical custody that we talked about before. So the question is, what does this mean? Because those terms are pretty general, and it's a little hard to figure out how it works in the real world without putting some flesh on those bones. So here's what I think is the consensus view of what these terms really mean. Joint legal custody is pretty easy to define. The statute is pretty helpful about that, I think. It means equal authority to make major decisions. So it is possible for a court to order joint legal custody, which essentially means you walk out of court with exactly what you walked in with if you're parents. And that may be a perfectly acceptable arrangement. It may be what's in the best interest of the child, or it may not be, and that will be part of your role as a guardian ad litem to figure out. The court can, however, also order sole legal custody, and that essentially gives sole decision-making authority to the custodian. That individual gets to make the big decisions about the child's health and welfare and education and life. The court can order joint physical custody. That is a term that I think no one can really define. It doesn't really lend itself naturally to a definition, and I don't think there are any cases that really define it well, and I don't think lawyers and judges can really give it much of a definition. I think if pressed, most people would say that the child's time would be divided 50-50 between the two custodians. But again, there's no really explicit definition of joint physical custody. It's a term that's pretty unclear. Sole physical custody, I think the consensus view is that it means that the child lives with the custodian. The child is spending the majority of the time with that custodian. That custodian provides the child's residence, and then the other custodian, the other individual, the other parent or other party has other rights to access, rights to visitation. So I think these definitions are helpful to give you a slightly better idea of what it means. But again, it only gets you so far. It doesn't, I think, really give you a picture of how these arrangements can work in the real world and what kind of court orders you can get. What level of generality or specificity is available in a court order. So I want to talk a little bit about what this really means. And what it really means, I think, is that the judge has very broad discretion to fashion an order, to fashion a custody arrangement. And you're really only limited by your creativity and by what is possible in the real world and by what you think is in the best interest of the child. So I want to give you some examples, and these are only examples of language that you may find in an order or ideas about how you can think about fashioning a custody arrangement or custody order. And I kind of think of it as a spectrum from general language or general arrangements to very specific language and specific arrangements. So I'm going to give you, I think, some examples on both of the far ends of the spectrum. But you can really come up with your own wording, your own ideas. Whatever you think is going to work and going to be in the best interest of the child is something you can advocate for. And you can mix and match. You can have general language about one thing, specific language about another thing. You can have umbrella language, but then flesh it out a little bit with specific language. So let me give you a few examples of language that you may see in a court order. You may see very general language. You may see language that simply says joint legal custody. You may also see things like shared legal custody. I know that the statute uses the terms sole and joint, but you don't have to use those terms. And increasingly, we're seeing other terms being used, like shared or primary. And I think that's for a lot of reasons. I think one of the reasons we see that is that those terms are sometimes a little less stark, a little less confrontational, and it may help parties reach an agreement to use terms that don't seem as though they're depriving a parent of something, or they don't seem as combative or exclusive. So you're going to see other language. And again, you can use other language as long as you feel the language is suitable and appropriate and sufficiently clear. So again, you may see the terms joint legal custody or shared legal custody. You also may see arrangements, or may want an arrangement that lawyers and judges often call joint legal custody with tiebreaker authority to one parent or one party. So what that typically is interpreted to mean is that both parents start out with equal rights. They can both make decisions about where the child goes to school, or who the child's doctor is, or whether the child is in therapy or not, or what religion the child practices. But if they disagree, then one parent does get to make the decision. So again, it sort of enhances this idea that there's collaboration, that both parents can make these decisions, but ultimately if there's a disagreement, one parent has final authority. And that may be an arrangement that works in your case, or it may not be a good idea in your case, and that's what you'll have to figure out. With regard to joint physical custody, I think it is somewhat rare to see an order that says joint physical custody without any further definition. It's not impossible, but because that term is so unclear, I think you're not going to see it very often. Nothing can be ruled out, but it's just sort of a caveat to think about whether once you walk out of the courtroom, is that going to be a workable order? But what you do see is are orders that say joint physical custody, but then they do provide a little bit more of a schedule. And again, I think sometimes an order is crafted that way, or an agreement is crafted that way to make both parents feel good about the outcome. It's not as though one parent won and the other parent lost. They have joint physical custody, but a schedule of some sort is needed, whether it's a very general schedule, a very flexible schedule, or whether it's a more specific schedule. So sometimes, again, you will see wording like that, joint physical custody, but with more specifics. Another arrangement that is not uncommon, not surprisingly, is that one parent does get sole physical custody. But again, you're not wedded to the use of the term sole. The court isn't wedded to the use of that word sole. So increasingly, we're seeing the phrase primary physical custody or primary residential custody. And I think those terms are relatively clear. They typically will mean, if there's no further definition, that the child lives with the custodial parent, the parent with sole or primary or residential custody. And if you see a phrase like that, or use a phrase like that, then typically you're also going to have some kind of provision about visitation or other custodial rights. Again, you don't have to call it visitation if it seems that that's not a word that's being accepted. You could talk about physical custody every other weekend, or physical custody every other weekend and one night a week. But essentially, we're talking about a visitation schedule. And again, you could see very general language, such as reasonable rights of visitation. There are court orders that say that dad has primary physical custody and mom has reasonable rights of visitation. Or you may see a very basic visitation schedule, every other weekend visitation, 4 weeks in the summer, holidays are divided up. So again, you can craft this however you want, but those are sort of typical general provisions to address legal and physical custody. So that's what I call the general end of the spectrum. Now on the specific end of the spectrum, you could get as specific as you want. You could have an incredibly detailed process around decision making. You could talk about who gets to make what decisions, how input is regulated, how much notice people have to give other people of the decisions, how the input is going to work. You can have mandatory mediation, you can have mandatory arbitration, you can have time periods within which parents have to get back to each other, but if they don't, then one parent can make a decision. You could micromanage this to within an inch of its life if that seems like a good idea. You can also micromanage physical custody. Now, you can have any physical custody arrangement you want. You can have primary physical custody with one parent. You could have a week on and a week off. You can have half the week with one parent. You can have half the week with another parent. So again, those are, I call those general arrangements, even though in the final analysis, some of them do and give you a much more specific schedule. But again, you can have very detailed arrangements if you want. You can have detailed arrangements about the days of the week. You can have detailed arrangements about pickup and drop off for changes in physical custody or for visitation. You can specify time, place. You could say that the child has to bring her pink Oshkosh B'gosh overalls and they have to be returned freshly laundered. You can really be as specific as you want. The court can be as specific as it wants, or if the parties can reach an agreement, they can be as specific as they want about these arrangements. So that's just a taste of what you can do in a custody order, but I hope it gives you a sense of just how flexible or creative you can be, how you can run the gamut from very general provisions to very specific provisions, and how you can mix and match. Now I want to talk a little bit about what the legal standard is if the court has to make a decision. In other words, we've talked about what kind of custody arrangements a court can order, but I want to talk about how the court makes that decision if, in fact, the parties cannot reach an agreement, and the judge is the person who has to decide. I want to talk first about the legal standard in parent versus parent cases. There is a statutory standard, and that is the best interest of the child. That's what the statute says, that the court decides custody based on what's in the best interest of the child. In addition, the statute lists 17 non-exclusive factors that the court must take into consideration. Now, we haven't put those 17 factors on the slide because, frankly, you're just going to have to read them when you do your case. And the other reason we haven't put them on the slide is in many ways they're very, very common sense factors. They address, they include what I call parent-focused factors. The mental and emotional and physical health of the parents, essentially the parent's fitness, the parent's capacity, the parent's situation, the kind of environment the parent is providing for the child. In addition, they're what I call child-focused factors that sort of help you look at the world from the perspective of the child. Who's been the primary caretaker, the child's connection to the parties and to other significant people in the child's life, the child's connection to school and home and community. Where are the child's relationships and connections? Because that's going to be relevant to what's in the child's best interest. And there are a few other factors that are a little quirky and don't necessarily apply in every case. It's pretty clear what they mean. And again, they often aren't relevant at all, in which case you don't really have to address them that seriously. So you'll read those factors, and we can certainly help you think them through in the context of your individual case, but they're pretty, again, they're pretty common sense, and I think it's going to be pretty obvious what they mean. The factors are non-exclusive. So what that means is that the court must take them into consideration, but can take into consideration anything else that is relevant to the best interest of the child. And my view, and I think most judges' view, is that almost anything is relevant to the best interest of the child. I mean, perhaps not everything, but most things relating to the parents, to the child, to the history of the family, is going to be relevant. So there's really very little, I think, that isn't relevant to what's in the child's best interest. So you're not limited to facts that address these factors. I mean, most facts can be tied into them, but they can't always be tied in that closely, but there may be many, many facts that are still relevant to what's in the best interest of the child. But it is true that the court must consider these factors. And you will see often the judges, in addition to the other material, the other text that they put in the orders, will at some point at least list each factor individually so that it's clear to the Court of Appeals, if anyone ever appeals the decision, which doesn't happen often but could happen. It will be clear that the judge did at least do what is absolutely required, which is consider each of the factors. Typically, you're not going to want to tell your story about what's best for the child by making a list of factors, but again, because the judge does have to consider them, you're going to want to consider them as well and be aware of them. And again, the fact that the factors have to be considered doesn't mean that there's always information relevant to each factor. And sometimes if a factor just isn't germane to a particular case, the judge will note the factor and say that he or she considered it, but say it really isn't relevant to the particular case. So you don't have to struggle to find information that's relevant to a factor if the factor itself really just is not significant in your case. There are a couple of other things that I want to mention about the legal standard in parent-parent cases. There is a statutory presumption in favor of joint custody. Now, the statute does not say whether it is a statutory presumption in favor of joint legal custody, joint physical custody, or both. So the statute's not clear. I think it's fair to say that most judges and lawyers interpret the statute as a presumption in favor of joint legal custody. Because as a practical matter, unless the parents agree to it, I think that many judges and many guardians ad litem, to be frank, find that a 50-50 physical custody split is probably not in the best interest of the child. You really can't make generalities in custody cases. Everything is really fact-specific, but you can imagine that a 50-50 split of time is often not a good arrangement or not a practical arrangement unless the parties agree to it and it seems like it really will be workable. In some ways, it's a lovely ideal that both children have both parents involved in the child's life equally, and that idea is often a touchstone for judges and GALs, that ideal, but the ideal is often not achievable. So again, most judges and lawyers interpret this presumption as being a presumption in favor of joint legal custody. The presumption, however, can be rebutted. And it essentially can be rebutted if you can show that it's not in the best interest of the child for there to be joint custody. So in essence, you may not be doing anything more than you would be doing anyway if you are advocating for some kind of sole or primary custody arrangement. I do want to mention that some judges in some cases take this presumption very, very seriously. And in other cases, you're going to find that judges don't even mention the presumption, and they might mention it in the final order because they realize they have to, and they just have to say, oh, the presumption's been rebutted. but they don't sort of pull it out as a separate legal issue. So you'll have to kind of gauge how much you have to address the rebuttal of the presumption as a kind of discrete legal issue, assuming that you do want to rebut it, or assuming that you don't want it rebutted and you want to invoke it. You'll have to see whether you have to really address it specifically and individually, or whether you don't. And that's something we can help you assess depending on who your judge is and what the facts of the case are. Essentially, though, if you want to rebut it, you will do it by showing that joint is not in the best interest of the child. In addition, you'll see that the statute provides that the presumption flips under certain circumstances, that there is a presumption against joint custody if the court finds during the course of your custody case, or has found in the context of another case, that a party has committed an intrafamily offense, or child abuse and neglect, or parental kidnapping as defined by statute. All of those terms are defined by statute. So if an intrafamily offense has been committed, which is essentially a crime between two people who have a familial relationship, or child abuse and neglect is defined by statute, or parental kidnapping is defined by statute. There is actually a crime of parental kidnapping. There is a specific definition. It's not every time that there's a visitation dispute. So if any of those three things are proven up during the course of your case, or have been proven in another case, for example, in a criminal case, the presumption in favor of joint custody flips to a presumption against joint custody. Now again, that presumption against joint custody can in turn be rebutted, but you're starting from a very different place, obviously. So that is an important issue to know in terms of whether that presumption, which presumption is going to apply or not. So that's the basic legal standard with regard to a parent-parent case, and that's really what there is in the statute. There are some cases, obviously, that you can read to try to flesh this out a little bit more, but there aren't a lot of appellate cases in the custody arena, but there are some. I want to turn to third-party custody cases and talk about the legal standard in third-party custody cases. First, I want to highlight that there is a threshold requirement in third-party custody cases, which is a standing requirement. In order for a third party to be awarded custody rights, that third party must have standing. And there are basically 4 bases for standing in the statute, and I'm going to go through them very quickly. One basis for standing is that a parent who is or has been the primary caretaker for the child at some point within the past 3 years consents to the third party filing for and having custody rights. That's all the statute says. It doesn't flesh that out anymore. So there are a lot of unanswered questions about that basis for standing, and we'll have to see how they develop over the course of time. But that's what the statutory language is. Another basis for standing that's very common is that the third party has lived in the same household as the child for at least 4 of the preceding 6 months, the 6 months next preceding the filing of the action, or if the child is under 6 months old, for at least half the child's life, and the third party has primarily assumed caretaking responsibilities. So the basic idea is that the child has to have lived with the third party for this designated period of time, and the third party really was a primary caregiver. The parent could be living in the same household, but the third party really has to be a primary caregiver for this child, not just essentially a landlord or a nanny. A third basis for standing is that the child is currently with the third party and there are exceptional circumstances such that relief is necessary. This is what we call the catch-all. The child is with the third party. There's no other basis for standing, but there's an important reason in terms of the child's best interest as to why the court should grant custody of some sort to the third party. There's another basis for standing, which is called de facto parent. There is a more detailed definition of de facto parent in the statute. I'll summarize it by saying that, that a de facto parent is essentially someone who, with the agreement of a parent, has held herself out as a parent, him or herself out as a parent. So the parent and the third party must agree that the third party holds him or herself out as a parent. And then, in fact, that third party must act in the real world as if he or she were a parent. This provision was designed for gay and lesbian couples before there was marriage in the District of Columbia, before there were amendments to some laws that made it easier for gay and lesbian couples to be married, to be actually recognized as co-parents of children. But this statute does allow a non-biological parent to be a de facto parent, in which case he or she is treated exactly like a parent. And in theory, it is possible for heterosexual couples, for a heterosexual individual in a partnership to be a de facto parent, but the statute was designed with gay and lesbian couples in mind. So those are the bases for standing for third parties. And right now, it appears as though it is sufficient simply to plead that you have standing. You don't have to sort of come up with exhibits or affidavits or something like that to go along with your initial pleading to show that you have standing, although you certainly could. But ultimately, if standing is contested, then it is something that would have to be proved through evidence as part of the custody proceeding. Once, however, you've established standing, either because no one objects or because you've actually litigated it, there is a legal standard that the court applies to decide whether or not to give the third party custodial rights. And it's a two-part or two-prong standard. First, the court must find that what's called the parental presumption has been rebutted, and then the court must also find that the custodial arrangement is in the best interest of the child. So let's talk about the parental presumption first, briefly. The parental presumption is what our Court of Appeals has decided a parent is constitutionally entitled to. You may remember from your constitutional law cases that a parent's right to custody is a fundamental constitutional right, which means that it's entitled to heightened protection if someone wants to take those rights away from you. And so one aspect of that heightened protection is that there is a presumption that it is in a child's best interest to be in the custody of a fit parent. So that's what we call the parental presumption. However, that presumption can be rebutted in a number of ways. The statute does address how you rebut the parental presumption. I will tell you that the statute is somewhat vague, but it will give you some guidance. Certainly you can prove that a parent is unfit, but it is also possible to rebut the presumption without actually proving that a parent is unfit. It may be that it would be detrimental to the child to be in the custody of the parent, even if the parent might be fit to raise a particular child. So you can take a look at the statute. Again, the statute is pretty new, so there's not a lot of case law. There's not a lot of guidance out there for the court or parties or litigants. But there is some guidance, and we can help you think through how to shape your advocacy if you do believe that custody should be given to a third party. In addition, if the parental presumption is rebutted, the court still it sort of puts the parent and the third party on a level playing field, and the court still has to ensure that custody with a third party is in the child's best interest. And the statute has 4 non-exclusive best interest factors that the court must consider. There are only 4 factors, unlike the 17 that are listed for parents, but it's the same basic idea. The court must consider them, but can consider anything relevant. The factors, again, are very common sense. And while the 17 factors in parent-parent cases are not part of the third-party custody statute, I think they're still instructive, and you can think about them in terms of deciding what's in the best interest of the child and in terms of deciding how to shape your advocacy once you've taken a position about what's in the custody best interest of the child. There is a rebuttable presumption in the third-party custody statute that it is not in the best interest of the child to grant custody to a third party who has committed an intrafamily offense, to a third party who has committed domestic violence. So that's the basic framework of the legal standard for third-party custody cases. And again, the statute's very new. It was enacted in 2007, so everyone is starting to work with it for the first time. Before 2007, third parties did file for legal custody all the time, and they were often granted custody, and the same is true now. But now we do have a more explicit statute and a somewhat more extensive case law about this notion of parental presumption, even though there aren't many cases, and they tend to arise in the context of adoption and not custody. But there is still some case law that you can draw on. I want to turn just for a moment to jurisdiction. Now might be a good time to say that, in essence, I'm giving you a backdrop of the law and procedure of custody cases. Some of this information will be very, very relevant to what you do in the case. Some of it's going to be by way of background and context, so you understand the bigger picture of a case and how the parties got to where they are in a case. And I think that background information is very useful. And jurisdiction is one of those background issues. Typically, it won't be an issue in your case, but I have to tell you that sometimes it is, which is why I do want to mention it briefly. There is a statute that tells us what state has jurisdiction over custody cases. It's the Uniform Child Custody Jurisdiction and Enforcement Act. It's a model law. It's a uniform law. It's been enacted, if not by all 50 states, by at least 48 or 49 states at this point. So it is a law that is uniform across states, unlike most family law, which, while you can sometimes find themes that tend to be uniform across state lines, often family law, substantive law, and procedure does vary from state to state. So that's just an important thing to keep in mind, that family law typically is left to the states to develop, and family law can be different from state to state. But the UCC JEA is uniform. And it tells us what state is the proper state to file a custody case in, or what state can make a custody determination. There is something called a Custody Jurisdiction Interactive Decision Tree that was developed by the DC Family Court Self-Help Center. It's online, and it's actually very helpful. It asks you questions, and depending on the answer, it asks you other questions, and will ultimately tell you whether DC is the right court or not in most situations. So I want to just flag some basic UCC JEA principles for you. The most important one is that only one state at a time can hear a custody case. 2 states can't have jurisdiction. You can't, both Maryland and DC can't make a custody decision. It's going to be one or the other. The UCC JEA divides custody determinations into 2 categories: initial jurisdiction and modification jurisdiction. If this is the very first time the court is being asked to make a custody determination, has made a custody determination, then there's one analysis. And the basic analysis is that if the child has a home state, as defined by the statute, that's the state with jurisdiction. And the home state is basically the state where the child has lived with a parent or person acting as a parent for 6 months immediately preceding the filing of the action. In addition, if the child had a home state, but then the child moved, but there is a left behind parent, that left behind, that state remains the home state for 6 months. So it gives the left behind parent a chance to sort of catch up. So if everybody lived in DC, but then the child and a parent moved to Maryland, but one parent still lives in DC, that parent has 6 months to file in DC. But at that point, DC will lose jurisdiction because DC is no longer the home state of the child. Now, if the child doesn't have a home state, and that can happen sometimes, there are other criteria set out in the UCC JEA to tell us which state has jurisdiction. I'm not going to dwell on them because, again, with any luck, you won't have a UCC JEA issue in your case, but I just want to flag that the statute does give you an analysis. So that's initial jurisdiction. But let's say there was a custody case in DC a few years ago, and DC issued a custody order, but someone wants to modify it, and we'll talk about modification later. Well, there's a different analysis for modification jurisdiction, and the basic principle is that the state that had jurisdiction to issue the custody order in the first place has exclusive continuing jurisdiction to hear future custody determinations unless that state loses jurisdiction. And the statute tells us when that state loses jurisdiction. The most common way that a state loses jurisdiction is if everybody moves. So if DC had jurisdiction, but nobody lives in DC anymore, none of the custodians, no parent, nor the child, then DC has lost jurisdiction, and you do an initial analysis to find out which state has jurisdiction. So this is an enormous oversimplification of the UCC JEA. There are a lot of exceptions, there are a lot of sort of provisos, but those are the basic principles that I just want to flag for you. And so what I call UCC JEA red flags are the following situations. If a child has lived in DC less than 6 months, sometimes you want to take a closer look to see if DC has jurisdiction. If there was a previous custody order either in DC or somewhere else, is DC the right place? Or do the parties live in different states? Then you might want to ask yourself, is DC the right place? Again, DC may very well be the right place, but it might not be if there has been that kind of movement or if people live in different places. So what I tell lawyers for the parties, as opposed to the GAL, is before they file, this is the kind of thing that they really want to think about and ask about. Now, the issue may come up for you in one of two ways. Either someone else may spot a UCC JEA issue and you may be asked to weigh in on it, to give the court your legal assessment evaluation, and we can, again, help you walk through that if the time comes. Or you may spot a UCC JEA issue that no one else has spotted. And I like to mention that because I think it's an interesting illustration of some of the challenges that arise occasionally in terms of you figuring out what your role is. If you spot a UCC JEA issue, you will have to decide whether you feel you need to disclose it to the court, or whether, if you believe that it's in the child's best interest to have a custody decision made in DC and no one else has identified this issue as an issue, do you have to bring it up to the court? Perhaps you don't. Now again, those kinds of challenges don't arise very often for GALs, but they do arise occasionally, so I just like to highlight it as part of the training. But again, with any luck, this dilemma won't arise for you, but if it does, we will help you work it through. So we've kind of walked you through the law of custody up to the courthouse door a little bit. We've talked about what the substantive law of custody is, who has custody rights, how the court can allocate them, what kinds of custody arrangements are available, what the basic legal standard is. So now I want to talk about the procedure of the cases that you're going to be involved in, sort of the step-by-step process that you're going to be engaged in these cases. And I'm going to start by talking about procedure in divorce and custody cases. Those are colloquially known as DRB cases because they are filed in and heard in the domestic relations branch of family court, of superior court. If you think back to that flow chart, that's where you are. That's going to tell you what clerk's office you're going to use for the administrative aspects of the case, and it's how the court decides how to assign judges to the various divisions and branches of the court. Right now, and this will probably remain the same for the foreseeable future, there are 5 what are called domestic relations 2 calendars to which divorces and custody cases are assigned. So there are 5 judges who are assigned to the domestic relations branch, to the DR2 calendars, and those judges will hear divorce and custody cases as well as a few other kinds of cases that are assigned to DR2 calendars. There is also a what's called a domestic relations 1 calendar. Typically, cases aren't assigned to that calendar right at the time of filing, but a DR2 judge could certify a case to that calendar, or you could request, any party or litigant or counsel can request that a case be certified to that calendar. That calendar was created for what are called more complicated cases, but there's absolutely no definition or governing law or court rule that really talks about these 2 kinds of calendars and what kind of case should go to a DR1 calendar. So you will typically be on a DR2 calendar, and once in a while a judge may certify you to a DR1 calendar, or you may decide that you'd like to be on a calendar that is for more complex cases where there might be scheduling issues or where the judge might have a little more time to focus on your case. But usually it's perfectly appropriate to be on a DR2 calendar, and you won't want or need to be on a DR1 calendar. The administrative functions of our court, like any court, are handled by the clerk's office, and there are 2 important places in the clerk's office that you're going to want to know about. One is simply called the Family Court Clerk's Office, and it is located in room JM 300 of the court. And the most important thing about the Family Court Clerk's Office for your purposes is going to be that it's the file room. It's where all the hard copies of the court files in family court cases are kept. So if you need to get a copy of the court file, which in fact you are going to need to do at the beginning of your case, that's where you're going to go to order up a copy of the file. If you need to look at some other family court file, perhaps a litigant in the case is going to have another family court matter going on at the same time or that went on in the past, that's where you're going to go to check out the file and take a look at it and make a copy of it. There's another office that is a part of the Family Court Clerk's Office that's called the Family Court Central Intake Center. And that's located in room JM 520, but it's not really a room. It's a very big filing counter. It's a very big counter at the end of the hallway on the JM level of the court. And the Central Intake Center, CIC, is where all family court pleadings are filed. So the main clerk's office houses the file room, and obviously it houses a lot of things that are going on behind the scenes in terms of, maintaining the files and maintaining the court's docket. But you actually file pleadings through CIC. So that's where you will go to file any pleadings that you may need to file. And you may never need to file a pleading, or perhaps the only pleading you may want to file, it's not really a pleading, the only document you may need to file is what's called a precipe, through which you enter your appearance. It's an administrative form that judges like you to file that has all of your contact information in it, or you may end up filing pleadings. You may file motions, you may file proposed findings of fact and conclusions of law. Whatever you file, though, you'll file through CIC. I want to highlight a couple of other things about sort of the administrative functioning of the court. Unlike some court systems, there is no information available online for DC family court cases, and I think it's not likely that there will be for the foreseeable future. For certain kinds of DC Superior Court cases, cases in the Civil Division and cases in the Criminal Division, there is some information posted online. It's not very complete information, but you can get some information. But there is no information online for family court cases, for divorce or custody cases. There's also no information posted online for civil protection order cases. I want you to know about CourtView, though. CourtView is the court's electronic database, and it is the source of some of the information that does go online when there is information posted online. But essentially, the court does have an electronic database now. And probably the most important thing from your standpoint is that that's how the court's docket is maintained. The running chronology of everything that happens in the case, pleadings that are filed, orders that are entered, hearings that are held. You know, the docket has always been the summary of court action, and it used to have to be maintained by hand, and now it's done electronically. And you can get a printout of that either at CIC or at the Family Court Clerk's office, and it's often a helpful summary of court action. In addition, most pleadings and orders in all cases now are scanned into CourtView. In some kinds of cases or some older cases, they haven't been able, they are not scanning pleadings and orders. But in many, many cases, many documents are scanned. And again, that's a useful thing to know because you may need, even though you're going to get the entire file in your case at the beginning of your involvement, every once in a while, especially pro se litigants may file pleadings and not serve you because they don't understand that they need to do that. So you may have to get an isolated pleading from the court. And often you can just go to the Family Court Clerk's office or CIC and they will just print it out for you. Or you may find, again, other cases that have relevant information and you want to print out some of that information, get some of that information. You can always check out the hard copy file. And in fact, you may want to do that because there's often a lot of information in the file that's not actually, there may be information in the file that's not scanned, although most documents are scanned, but you still may want hard copies of those documents, and it may just be easier to get them printed out than actually photocopied by the clerk's office. Right now, there is no e-filing in custody cases, divorce cases, and there is also no e-filing in civil protection order cases. However, e-filing is coming to family court. So there will be mandatory e-filing for attorneys, in other words, for parties represented by counsel, in divorce and custody cases. We have been told that e-filing will be mandatory as of August 2012, but we will have to see what happens, and we will certainly keep all of our pro bono attorneys posted on the status of e-filing and what the procedures are for e-filing. It's not a complicated process. There has been e-filing in other divisions of the court for some time now. E-filing will, in the beginning, be for pleadings not including the initial pleading. And again, as GALs, you don't really have to worry about the initial pleading, the filing of the initial complaint, but just so you know, there won't be e-filing for initial pleadings, but there will be mandatory e-filing for lawyers after that, and we are assuming that that will apply to GALs, and we will confirm that. So that's kind of the basic administrative infrastructure of the court. So now I want to walk you through what I call the life cycle of a DRB case, the life cycle of a divorce and custody case. And again, divorce and custody cases are procedurally essentially going to be handled very similarly. The first step is that a complaint is filed by the plaintiff. At the time of filing, the case is assigned to a judge right then and there, and it's done randomly. In addition, at the time of filing, some other things are going to be scheduled. First of all, the initial hearing in the case will be scheduled, and the plaintiff will be given a notice of that. A notice will also be mailed to the defendant at the address provided by the plaintiff on the pleadings, which may or may not be the correct address. In addition, the court, in any case in which custody is an issue, and in which a consent answer has not been filed at the same time, which can happen sometimes in a divorce case. It may all be consensual, and even in some custody cases it may be consensual, but not in the cases you're going to be involved in. So in any case in which custody is, at the time of filing, a disputed issue, the court is going to schedule 2 other dates. The clerk's office right then and there is going to schedule 2 other dates. One is called a PAC date, and the other is called a mediation intake. PAC is the Program for Agreement and Cooperation, and it's a program that was implemented by the court several years ago that essentially consists of a 1-session, large group parent education class. It's typically held on Fridays, not Fridays, Saturdays. And it is a large group. It's not an individual session for the particular litigants. And it's designed to try to encourage parents or third-party custodians to understand the impact on children of custody disputes and to try to minimize the negative impact of that on children. There's also a class for children between certain ages. I think it's roughly the ages of 5 to 16. There are more details about these programs in your written materials. So the PAC session will be scheduled, and a mediation intake will also be scheduled. The parties will be directed to go to the intake and participate in mediation. So those sessions will be scheduled, and those notices will issue to both parties. And that, once the complaint is filed, the case is initiated. At that point, the plaintiff is responsible for effecting service on the defendant, or defendants if it's a third-party custody case where a third party is filing against both parents. And then the defendant has to file an answer indicating whether the parent consents or objects, just like any other civil case. Or if no answer is filed, then the plaintiff can enter a default, can ask the court to enter a default, and the court can proceed on the merits of the custody case, even if the defendant has not filed an answer. So after the complaint has been filed, the next event typically is the initial hearing. Sometimes the plaintiff has filed, even before the initial hearing, an emergency motion for temporary custody. So sometimes you're going to see that kind of motion has been filed, and it may have been granted. It may have been denied. If it's denied, usually in essence it's denied without prejudice, because what has happened is that those emergency motions are held ex parte without notice to the other side. So the judge may in essence be saying, I'm not going to give you temporary custody unless and until the other side has had notice, and then we can all come to court and we can make a decision. So you may see in some of your cases some court activity before the initial hearing, again, usually because someone's filed an emergency motion for temporary custody. But typically the first event besides that is the initial hearing in the case, and it really is an initial hearing. It doesn't really have an agenda. It's the first opportunity that the court has to meet the parties and try to figure out what really is in dispute in the case and figure out how to manage the case going forward. At some initial hearings, the defendant hasn't even been served yet. And in other initial hearings, the defendant has been served and comes to court, and so the court can move forward at that point. So it's often very unclear what may or may not happen in an initial hearing, but there are some issues that the court may be prepared to address in an initial hearing and may in fact have addressed at an initial hearing. The court might enter a temporary custody or visitation order. The court might have entered a discovery schedule. That's less likely in cases with pro se litigants, and there are many, many, many cases with pro se litigants. Probably the majority of cases in family court custody and divorce cases involve pro se litigants. Anywhere between 60 and 80% of the cases, one or both litigants will be pro se. It is possible that at an initial hearing, the court would have encouraged the parties to go to mediation. Even though there is an initial directive from the court at the time of filing that the parties go to a mediation intake and schedule mediation, most judges are actually, after that point, reluctant to order mediation if the parties don't want to go. The judge might exert a lot of pressure on the parties to go, and the parties may agree to go, and some judges may in fact order it. But notwithstanding the fact that there is an initial order for mediation, if one party or both parties really resist, I think most judges probably wouldn't force the parties to go to mediation. But again, mediation certainly is on the table, so to speak. And the parties may agree to go, or the court may pressure them into going or order them to go. There's some other things that the court may order that are talked about in other segments of the training, and about which there are materials in your written materials or your CD-ROMs. The court can order something called a home study. The court can order something that is variously called a forensic evaluation, or a custody evaluation, or a mental health evaluation, or a psychological or psychiatric evaluation of the adults or the children, or all of them, to get a better sense of the parenting capacity of the adults, to get a better sense of their relationships with the child, to get a better sense of the child's emotional needs and the child's relationship with those adults. So that's something the court can order. And the court, of course, can appoint a guardian ad litem. And the judge may do these things sua sponte, or the judge may do these things upon the request of parties or counsel. So that's kind of the agenda of initial hearing. None of those things may happen. All of those things may happen. Some of those things may happen. And then at an initial hearing, the court will decide what the next court date is and schedule it right then and there. It is very, 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 very typical for the next court date to be a status hearing. It is very typical to have at least one, and often many, status hearings in the case for all kinds of reasons that you can probably imagine. If the litigants are pro se, these cases can be a little more difficult for judges to handle, so they often want to give the litigants some time to try to settle the case, to try to get oriented to how things have to work in court. Again, encouraging settlement is often a reason for delay, to let the parties try to work things out, to let some of the emotions die down. In addition, the court may need some time to get some of these other things to happen: mediation, home study, forensic evaluation, and the appointment of a guardian ad litem. So status hearings are a very, very common occurrence in these cases. In addition, I just want you to know, sort of looking ahead in the case, that judges will sometimes schedule pretrial hearings, and with them may direct the parties and counsel to submit joint pretrial statements. Judges won't always order pretrial hearings, but they often will. Now, pretrial hearings and pretrial statements in these cases are often not as rigorous as they are in civil cases, in which they really are a moment where the parties and lawyers are forced to really commit as to what the issues are, what stipulated facts are, what the witnesses are, what the exhibits are going to be, what the objections to evidence are going to be, so they can be hammered out. Occasionally you may get a process that is that rigorous, but typically it's not. But it is still an opportunity, and is used as an opportunity to try to choreograph things ahead of time for trial. Probably the most typical purpose for a pretrial hearing or a pretrial statement is to exchange witness lists and exhibit lists, although again, typically judges won't lock you into it, that if parties want to supplement those lists, at least pro se litigants or the GAL, the judge will let you. You may have to feel that out a little bit, and we can help you feel it out, but that is pretty common. Pretrial hearings can still be an opportunity to try to raise some evidentiary issues, especially if you want to raise them. You can bring them up, so they can still be used that way. And again, the judge may set a pretrial hearing, but if the judge doesn't and you think it would be useful, you can ask for a pretrial hearing. You are a full participant in these proceedings, and you can advocate for the procedure to take a particular form if you think that would be ultimately in the best interest of the child, if that will get you to a good outcome. So that's kind of the beginning stages of a case, kind of the typical process that a case will have followed up to the point at which you are appointed. And GALs are, I'm going to pause here because GALs are typically appointed after an initial hearing or after a status hearing. You can imagine that that's the point at which a judge might say, I think I need a GAL. I now know a little bit about this case. I've met one or both of the parties. I've read some pleadings. I have some idea of what's really being disputed here and some of the background facts. I need a guardian ad litem. So typically, after an initial hearing is when a court might say, either at or after, I want a guardian ad litem, or at or after a status hearing. And typically, the judges will tell the parties or counsel in open court, this is what I'm going to do. I'm going to seek out a guardian ad litem. There have been occasions where judges have appointed guardians ad litem after trial, but before making a ruling. They have gone through the entire process, heard evidence at trial, and then have said, I need a GAL. Doesn't happen often, but it could happen. Another situation in which GALs are occasionally appointed is default situations. And that happens, I think, generally for two reasons. It may be because the case is going forward in default, but it doesn't make sense that the case is going forward in default. For example, dad files for custody. Mom doesn't file an answer. Dad files for default because mom hasn't filed an answer, and the case comes before the judge in a default posture event in due course. But the child is living with mom. You can imagine that is not a situation when a judge is comfortable just ruling in favor of dad without more information. So we have seen cases in which the judge will appoint a GAL to see what is going on. A similar default situation in which GALs are sometimes appointed is third-party caregiver cases, when a third party has filed and no one has really come forward and contested. The judge may be comfortable fundamentally awarding custody to the third party, but because there's no one else there to test out the accuracy of what is being presented to the court, some judges, I think, want to do a little due diligence and have someone who does actually check out the situation and make sure that everything really is fundamentally okay. So that's another kind of default situation in which you may be appointed. In addition, I want to mention that a guardian ad litem might also be appointed in connection with a motion for modification of a custody order or a motion for contempt, in which one party is accusing the other of violating a custody order. We're going to talk about those situations in a second, but you might be appointed in that context rather in the context of a case in which custody is being litigated and determined for the very first time. So that's sort of the basic process of the case. Initial hearings, status hearings, possibly a pretrial. Now, at any point in the course of a case, the parties may settle. And in fact, the vast majority of custody cases settle, statistically. No matter how acrimonious the situation is in the beginning, there is a very strong chance that it will settle. And GALs can often play an important role in that. Now, I do want to mention that it is not your goal to settle the case, it's your goal to do what's in the best interest of the child, but settlement can often be a good outcome for the child. It has to be the right settlement, but having a case resolved via settlement rather than contested litigation is often a good outcome But not always. There are occasionally times when, in fact, certainly there are times when the parties won't settle, but even if they seem to be willing to settle, you really believe that the settlement is not in the best interest of the child. I think the most typical situation is when one party has really pressured the other party, and that is often in a situation in which there's been a history of domestic violence. So you do really need to be on the lookout for that. But having said all of that, many cases settle, and you will be very comfortable with the outcome, and settlement and avoidance of litigation could be a very good thing for the child. Typically, the end result of a settled case is a court order. The parties may reach an agreement. You may reduce it to writing and then have the writing be an attachment to a court order, or you may simply draft a consent order that is an agreement with essentially the judge's signature at the bottom of it. But typically what the parties want is a court order, not simply a private agreement, and typically that's what you will think, I think, is in the best interest of the child. Judges must accept the parties' agreement and issue a court order embodying that agreement unless the court finds by clear and convincing evidence that it is not in the best interest of the child, and that is a rarity. I'm not sure I've heard of a situation in which really that has happened. Judges, I believe, understand that they need to accept the agreement of the parties under that standard. Of course, if a case doesn't settle, you will have a trial. And in other portions of the training, we'll talk more about trial issues. Essentially, though, these are conventional civil trials. There aren't really a lot of special rules that apply because custody is an issue. The trial is conducted pretty much as a normal civil trial would be conducted. Ultimately, again, the end result of the case will most likely be a court order, either a consent order or an order after trial. And after trial, the court rules do provide that there has to be not only an order that just sets out what the custody arrangements are, but actual written findings of fact and conclusions of law. The court has to articulate what the facts are and give some rationale for the ruling. And in fact, you may, as the GAL, be asked to draft the proposed findings of fact and conclusions of law, and we can help you with that. We have models, and that's often a good thing because you can craft the findings of fact and the order the way that you would like to have it crafted. I want to give you one practice pointer about practice in DC family court. Family court can be more informal. It often is more informal. What do I mean by informal? Well, here are the kinds of things I mean. The court might rule on oral motions, whereas in other kinds of cases, a court would never rule on an oral motion. The judge would require that the motion be in writing. So people might make oral requests, verbal requests for temporary custody, for visitation, for modifications in the temporary orders, and the judge may rule on it right then and there without a written motion and even without an evidentiary hearing based simply on the representations of parties and counsel. Sometimes the rules of evidence are followed, sometimes they're not followed. I suppose that can be true in any case, but it's even more true, I think, in family court cases. So I do think that it's only fair to warn you that there may be a level of informality in family court that you're not expecting. The problem is that it's difficult to predict when that's going to be. Certainly the fact that there are pro se litigants, I think, heightens the likelihood that the proceedings may be handled more informally. We can help you figure it out depending on the nature of your case, what the issues are, who the judge is. So it's not completely unpredictable, but there's not a real blueprint for figuring it out. But we can help you figure it out in the context of your individual case. And what I usually say to lawyers and GALs is that if the court is being informal and that is working for you, go with it. If you want greater formality, if you think greater formality would be of benefit to you in terms of getting the outcome you want, then you should invoke it. Again, I'm not saying that family court is always informal. Sometimes you will get a very high level of formality or rigorousness, but you also can experience dramatic informality. So we just want to alert you to that. And again, let you know that if you want to invoke formality, then like any lawyer, you can do that. You can argue that you're entitled to a written motion. You can argue that you're entitled to an evidentiary hearing. You can argue particular rules of evidence. I want to very quickly mention the issue of child support. The reason I want to do that is that it is an issue often in a custody case, that in any of these cases in which the court can be asked to make a custody determination, the court can also be asked to make a child support determination. Sometimes the plaintiff will have requested support, sometimes not. It's completely up to the plaintiff. It's not up to the judge. I think our view is, and I think it's the correct view, that you are appointed solely on the issue of custody. That's what your appointment order is going to say, and that really is your role. And so typically you're not expected to get involved in the litigation around child support, and typically you won't need to get involved. But it may be a part of the case, and so I think it's just useful to know a little bit about it. And the real reason I want to mention it is that occasionally you can be helpful by talking to pro se litigants or even to counsel in cases in which the litigants have counsel about the child support issues, because they are often misunderstood. And sometimes you can clear the air about child support in a way that then facilitates a better resolution about custody. You can clear up some of the misunderstandings, you can clear up some of the emotion around it, and that can actually be helpful in getting you a good outcome in custody. So all I really want to tell you about child support is, again, it can be requested, but it doesn't have to be. There is a statute, just like the UCC JEA for custody jurisdiction, tells us what court has jurisdiction in child support cases. It's called the Uniform Interstate Family Support Act. And then there's a statute that tells us how the judge calculates how much child support is due. And it's called informally the Child Support Guideline. That's what everybody calls it. It's essentially a mathematical formula. It's pretty cut and dried. And it's based primarily on the party's gross income and a few other pretty discrete, pretty concrete things that can be factored in. Other court-ordered child support that's being paid, other biological or adopted children in the home. But it's really pretty cut and dried. The mathematical formula does all the calculating. The court has a little bit of wiggle room or discretion, but not very much in terms of how to do the calculation. And there is a computer program that the court uses, and that program is available online. So if this becomes an issue, we can point you to that, and you can use it with either real numbers or estimated numbers. So as we move you through the case, we want to talk about outcome, which is the order. In our mock walk through the case, we've kind of gotten you to the end of the process. Custody orders last indefinitely in DC until the child is 18. The order doesn't have to specify a duration. It just is in effect unless and until it's vacated, set aside, or modified. 18 is the age of majority in the District of Columbia. Kids are adults at that age. So family court cannot award custody of someone over 18. The judges have no power to do that. So if there's an existing order, it ends by operation of law automatically as of age 18. And if, for example, a child was 17 at the time that a complaint was filed but turns 18 before the case is resolved, most judges will tell you that it's a moot point and will not enter a custody order at that point. I do want to mention, though, because it often comes as a surprise, that if a DC court is the first court to enter a child support order, that order lasts until 21. a parent's duty to support a child under DC law lasts until the child is 21, even though the age of majority is 18. And there really aren't any exceptions to that. You have to be genuinely emancipated, which under DC law means really, truly self-supporting. And you don't see emancipation cases emancipation situations very often. As we've already mentioned, custody orders can be modified. So even if you've gone through the whole process and you've gotten a court order for custody, that order can be modified. So the term permanent custody, which you hear people use and you even see in court orders all the time, is a little bit misleading. It's a little bit of a misnomer. It doesn't matter whether you say custody or permanent custody. The court always has the authority to modify. And modification proceedings are initiated essentially by motions to modify. There is a legal standard for modification in DC. It is substantial and material change in circumstances, and that the new arrangement is in the best interest of the child. And this is one of those situations where some judges take that standard very, 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 very seriously. I mean, obviously they take the best interest standard seriously, but the change factor is sometimes taken very seriously, but sometimes judges just treat every request for modification as if they were deciding custody for the very first time. So again, you can feel out your judge and you can decide whether the extent to which you want to emphasize this aspect of the legal standard or not. The primary enforcement mechanism for custody orders is a motion for civil contempt. You'll also see motions to enforce the order. Those motions, the relief that they ask for typically is make a party obey the order. And that can be effective. The idea is you're getting the parties back into court to try to, get them to take the order seriously. Contempt actually could culminate in a party being sanctioned by imprisonment or a fine for violating the order until they actually comply with the order. You don't see those sanctions very often, though. What both of these motions, contempt and motions to enforce, really do is get the parties back before the court to try to get them to take the order more seriously, and that can work. But sometimes these motions do result in modification. So we do see GALs in the context of contempt motions and in the context of modification motions. In contempt, sometimes the judge is actually looking to the GAL to try to help litigate whether in fact the order is being violated or not. But also contempt can ultimately lead to modification, even if there's not a formal motion. That's where the informality of family court can take hold, and ultimately the motion for contempt may just morph into a motion to modify without a formal written motion being filed. So again, GALs could be appointed in connection with a motion to modify, and also in connection with a contempt motion or a motion to enforce a custody or visitation order. So that's kind of the life cycle of a DRB case, kind of the procedural process for a domestic relations case. I want to walk you really quickly through the life cycle of a civil protection order case, because it's a little bit different. These cases are also known as intrafamily cases or intrafamily offenses cases or DV cases. Again, they are creatures of statute, and there are court rules that govern the procedure in these cases. These cases are heard in the domestic violence unit of DC Superior Court. And the clerk's office for CPO cases is in room 4510. That's where the files are kept, and that's where you will file pleadings in those cases. There are 2 CPO calendars, 2 judges who are assigned to hear CPOs. And again, they rotate periodically, but those rotations tend to be fairly lengthy. The basic substantive law of civil procedures is that in order to get a civil protection order, the petitioner has to prove 2 things. One is that there is what I call a qualifying relationship between the petitioner and the respondent. and that the respondent has committed a criminal offense or threatened to commit a criminal offense upon the petitioner. So there has to have been a crime between the parties, and the parties have to have some kind of intra-family relationship as defined by the statute. An intra-family relationship as defined by the statute includes blood relationships, marriage, romantic relationships, dating relationships, and most notably for your purposes, having a child in common is a qualifying relationship. So that entitles you to file for a civil protection order. Typical crimes that are committed that are the basis for a CPO are assaults, threats, or stalking. They may be other crimes as defined by the DC Criminal Code, but those are the crimes that you will see most typically. If you are eligible for CPO, if you prove that you can get a CPO in court, you can get an order that lasts for up to a year. These orders can also be extended upon motion for good cause shown. The statute tells us what relief you can get in a CPO, and essentially you can get an order that the respondent not commit further offenses. You can get a stay-away order, a no-contact order, no contact by letter, phone, through a third-party intermediary or on social networking media. You can get move-out orders under certain circumstances. The respondent has to move out of the premises. And again, most importantly, for your purposes, the court can order temporary custody. And it's temporary essentially because the orders are time-limited. They don't last indefinitely. So the court can order temporary custody in the context of a CPO. The basic procedure is that a petition is filed, initiating the action and setting out the allegations in the case. Petitioners can request an emergency 2-week temporary protection order. They can go before a judge the day of filing and request this emergency order without notice to the other side. And it is fairly common for TPO requests to be granted. Then service of the court papers has to be effected on the respondent in order for the case to go forward. The petitioner can arrange for service to be effected or can request that the police serve the papers. The hearing on the CPO is usually set for 2 weeks after the date of filing, occasionally a little bit longer. And the reason it's so quick is that these cases, sort of by statute and by rule and by intent, are summary proceedings. Because they involve violence, the decision was made to streamline them, essentially, and get you into court a lot faster. If a TPO is issued, the hearing date will definitely be no later than 2 weeks away because TPOs only last for 2 weeks. So in the context of a CPO case, a GAL may be appointed at any time, and typically you're appointed either before the court has decided whether the petitioner is eligible for a CPO or after. In other words, the case might be set for a hearing, but the hearing doesn't go forward and for a lot of reasons. The parties request a postponement or the judge decides, I'm not ready to hear this, I need a GAL. So you might be appointed before any decision is made, or the court might have decided to issue a CPO, decide that the petitioner is eligible and in fact issue a CPO, but want to either defer the custody decision or make a very, very temporary decision and then bring a GAL in to really address custody. So the accelerated nature of these proceedings makes it a little more difficult. So sometimes you need to think about how you're going to approach this, and there are many, many options. The court may set a particular agenda on its own, or you may want to request a particular agenda. And here's what I mean by the different kinds of approaches. The whole hearing could be postponed to give you more time to investigate what you need to be investigated, so the court doesn't have a hearing at all. Or the court could bifurcate the hearing and make a decision as to whether there's an eligible relationship, an intrafamily relationship, and whether an intrafamily offense has been committed, so that the court decides that it can and will issue a CPO and possibly even issue one, but not make a decision about custody and give you more time to deal with custody, or again, make only a very, very temporary decision. Another possible scenario that happens pretty often is that there was already a domestic relations branch divorce or custody case going on, and then a CPO petition got filed. Or a slightly similar scenario is that the CPO case came first, but then after the filing of the CPO case, somebody filed for long-term custody in the domestic relations branch. And so there can be kind of an interconnection between those two cases. And so one alternative is that the court can issue a CPO with a temporary custody provision, but with a very distinct understanding, either in writing or orally, that the temporary provision in the CPO really is temporary, and that custody is going to be litigated in the custody case. So the CPO is binding as to custody, but only until everybody has a chance to really go in front of the DR judge and litigate custody fully. Or some CPOs specifically say custody will be governed by the order in the DR case, that the CPO ends up not addressing custody at all because now there's a DR case in which it is really more appropriate to take the time to litigate custody and make decisions in that context. So all of those things are possibilities depending on what's going on in your particular case. And finally, the last thing I want to mention about the procedure of CPO and custody cases is that the two cases can be consolidated and heard together by the same judge. Again, that can be done at any point in time in either proceeding. The CPO might have had a hearing and it might have been decided already, and then it could be certified, the cases could be consolidated and heard by the same judge so that the orders are consistent. Or it may be that the cases are consolidated before any kind of meaningful hearing is heard in either case, and all hearings are heard by the same judge. Consolidation will not happen automatically. The judge either has to do it sua sponte, or one of the parties, or you as the GAL, have to request that the cases are consolidated. So that's an overview of the substantive law and procedure of civil protection order cases and of custody and divorce cases in which custody can be determined. So we hope that that's helpful. There's a lot more information in your written materials. We are available for mentoring to any extent that you would find helpful, either answering questions or just brainstorming about your case. And again, we are incredibly grateful for your participation in the Custody Guardian Ad Litem program. Judges are eager and desperate for guardians ad litem. You're providing an enormous service to the court in terms of making good decisions, and to the litigants, and obviously to the children in terms of getting good outcomes. So thank you very, very much.